Welcome to week 4. This is the first in a series of lectures on the topic of the process of arbitration. And note that all of these lectures are on the process of commercial arbitration, which includes construction. It does not include the process of arbitration for labor disputes, those matters arising out of collective bargaining agreements, nor does it include the process for resolving most consumer disputes. Both of those areas of arbitration have different rules among the different providers and are often governed by different state statutory schemes. So again, this is on commercial arbitration, and we're going to begin with a review of terminology. Some of this might be a refresher from your contract or construction law course, but it's good to go over it again, particularly in the context of an arbitration process. This will help you better understand the terms and recognize them as you see them in other readings and as you begin to become more conversant in the field of arbitration. Also note that throughout this lecture series, we will be relying primarily on the American Arbitration Association's Standard Construction Industry Arbitration Rules. We're doing this because most of the construction industry standard form documents call for AAA rules, although in recent years some of them have left more leeway for the parties to insert other rules in their contract clauses, and parties are certainly always free to do that even if the AAA rules are in the actual form document. Both JAMS and CPR provide excellent construction services, including specific rules for construction arbitration. The first few terms we're going to go over are those relating to parties. In a court case, the party who files the initial claim and goes first usually is called the plaintiff. In arbitration, the proper term is claimant. If you use the term plaintiff, it's not incorrect, but it is better if you use the term claimant. Likewise, the defendant in arbitration is called the respondent. That is the preferred word to use in the context of arbitration. A cross-claimant or a cross-respondent are parties involved in a multi-claim case who have cases against each other, but are not the direct claimant and respondent. The best way to look at it is thinking of them as the parties on the same side of a V when you look at the caption of a case. So here we have Acme Company as the claimant, files for arbitration against Green, the respondent, and also about White, another respondent. In that same matter, White may bring a claim against Green. White and Green are cross-claimants or cross-respondents, depending upon who is bringing the claim and who is responding to the claim. The next term we just want to look at quickly is representative. In almost every case, a representative is going to be the party's legal counsel, but occasionally it may be someone who is not the party's attorney or not an attorney at all, but perhaps a business executive or just a business person who is more experienced in arbitration, who the actual party uses to speak for him or her at the hearing and act on behalf of the actual party throughout the procedures. But most of the time when you see the term representative, it is going to mean legal counsel. And a quick visit of some Latin terms. Pro se means a party who participates without legal or other counsel, basically a party who represents himself, as it says here. It is possible to go pro se in an arbitration, but is rarely done in a complex business dispute. And ex parte means for one party only. So if a motion is filed, for instance, and another party does not respond to it, and the arbitrator goes ahead and hears and decides the motion, that would be an ex parte motion. Here are a couple quick terms relating to arbitrators. A panel is just that, more than one arbitrator. It's usually a group of 3. It can be more, and there's no statutory requirement that it be an odd number, but common sense dictates that you need to have an odd number so you can have a majority decision if it's not a mutual decision of all of the arbitrators. And among those 3 or more arbitrators, one person is designated as the chair. There are different ways of doing that, and most rules have a default procedure if the arbitrators cannot decide among themselves. Those who are not the chair are called the wings. It is important to note that while some rules or party agreements may allow the chair to make decisions without consulting with the wing members of the panel, those might be decisions on discovery, and the parties would do this to expedite getting those rulings out. The important point to note is that the chair of a panel cannot make an award unilaterally. any decisions on the merits of the case must be made by the full panel. When you hear the term panel of arbitrators, it's important to make sure you know what type of arbitrators they are. Party-appointed arbitrators is a specific kind of panel of arbitrators. The most common definition is that the arbitrators are appointed directly by the parties, in the sense that the claimant appoints one arbitrator, the respondent appoints one arbitrator, and then those two get together and appoint the chair. Sometimes the two party-appointed arbitrators will use a service, such as a list from one of the ADR providers, to select the chair. That is the most general definition of a party-appointed arbitrator. Party-appointed arbitrators may serve as neutral arbitrators or non-neutral arbitrators. Sometimes the parties simply want control over having their choice sit at the table, but after that they want the arbitrators to act in unison as a panel and be neutral. And what that means is that there is no communication after the appointment between the party who appointed the arbitrator and the arbitrator. Party-appointed arbitrators, though, can also be non-neutral, and this is where most people think there's a benefit to party-appointed arbitrators, in that the communication between the party appointing the arbitrator and that arbitrator can continue. It usually does stop once the deliberations on the award begin. In a few rare instances, I have seen it go on up until the award is rendered, so that appointing party would have insight from his or her arbitrator as to what's going on. But these days, most people do stop the communication while that panel is deliberating. Another reason parties might choose to have party-appointed arbitrators is that they have a case involving a highly technical issue, and the pool of arbitrators available to have the right expertise and competence to hear that issue are few and far between. And if the parties use the party-appointed arbitrator mechanism, this gives them some guarantee of getting an arbitrator on the panel who has the right expertise to understand the subject matter of the case. It's important to take a look at AAA Rule R15 as it pertains to the process for party-appointed arbitrators. It's also important to note that arbitrators, like mediators, have a code of ethics. The specific sections of the Code of Ethics are called canons, and in review of the Arbitrator Code of Ethics promulgated by the American Arbitration Association and the American Bar Association, there are specific canons related to the conduct of party-appointed arbitrators, and you should take a look at those. There is a link at the end of this lecture series that will direct you to the Arbitrator Code of Ethics. Continuing on with some terminology relating to arbitrators, just like mediators, they must make disclosures. This is probably more important in arbitration because here the arbitrators are decision makers, unlike mediation, where the mediator has no authority to make a final decision on the case. Here, these people are making a decision on the merits of the case, and so it is important for the parties to know about any relationships or other connections they might have to the case. It is particularly important if the arbitrators may have a stake in the outcome. Those arbitrators usually will decline the case from the get-go. But again, review the Arbitrator Code of Ethics and review the disclosure procedures within the rules. And then finally, another term relating to an arbitrator is the oath of office. It's pretty much what it sounds like it is, and you can review that separately. Similarly, claims and filing forms are pretty straightforward. Who are the parties? Who are the representatives? What's the contact information? Often the document that starts a case is called a demand for arbitration. An answer is a document from a responding party that simply replies to the demand but does not contain any other claims. If a party has a claim against the filing party, it's called a counterclaim, and as we mentioned earlier, a cross-claim is a claim between parties on the same side of a case. One other filing document is called a submission, and that's where the parties don't have a pre-existing contractual agreement to arbitrate. They can just sign an agreement either that they make up themselves or a form they obtain from one of the providers that says, here we are post-dispute, we are agreeing to arbitration, and it basically provides the same information. It's important to note that depending upon the organization and what may be in the party's contract, what the parties have to put down for a claim may be very minimal. It might just be a dollar amount with no reasoning. And as we'll look at later on in the process, there are mechanisms to flesh out the claim, and that might be a good idea before the parties actually start the hearings. One final note is that most of these forms are available electronically. You should go to the websites of the different providers and take a look at the sections of their sites which cover the filing process. We're going to pause here and pick up the procedural terms again in a moment.